In a crucial judgment delivered today, a constitution bench of the Supreme Court of India has by a 3:2 majority upheld the constitutional validity of the 103rd constitutional amendment, which introduced 10% reservation for economically weaker sections in education and public employment, popularly known as the EWS reservation. While Justices Dinesh Maheshwari, Bela and Trivedi and Pardiwala has upheld the 103rd constitutional amendment, Justice S Ravindra Bhat has written a dissenting judgment striking it down. Chief Justice of India, Uday Umesh Lalit, has concurred with the minority view of Justice Bhat. 4 judgments have been passed in this particular case. One judgment is by Justice Dinesh Maheshwari, the second judgment is by Justice Bela M. Trivedi, the third judgment has been passed by Justice Pardiwala, while the dissenting view is by CJI Lalit and Justice Ravindra Bhat. For those of you who are not aware of this particular issue, back in January 12, 2019, the Union government had brought about a constitutional amendment to Articles 15 and 16 of the Constitution, which deal with the right to equality and reservations. Prior to this, there were provisions for seats and jobs to be reserved for scheduled castes, scheduled tribes, and socially and educationally backward classes. Thus, pursuant to this amendment, the government introduced a 10% reservation for general category citizens who are economically weaker. The central government has particularly defined economically weaker sections as those with an annual family income of less than rupees 8 lakhs. Subsequently, several petitions were filed in the Supreme Court of India challenging this constitutional amendment on the ground that it violates the basic structure of the Constitution. We have made detailed videos on the arguments that were advanced as well as the courtroom exchange that took place during prior hearings before the Supreme Court, the links to which have been given in the description box below. Please do check it out. As per the majority view of Justices Dinesh Maheshwari, Bela M. Trivedi and Pardiwala, reservation structured singularly on economic criteria does not violate the basic structure of the Constitution. They have also held that the breach of the 50% ceiling limit by the EWS reservation does not violate the basic structure either. The majority judgment stipulates, and I quote here, reservation is an instrument of affirmative action by state so as to ensure all-inclusive approach. It is an instrument not only for inclusion of socially and educationally backward classes. Reservations for EWS does not violate basic structure on account of 50% ceiling limit because ceiling limit is not inflexible. Justice Trivedi in her judgment has stated that the state has come out with the amendment for the advancement of EWS categories, opining that the 103rd amendment needs to be seen as a form of affirmative action by the Parliament. Justice Trivedi in her judgment has stated, and I quote again, the impugned amendment has to be treated as an affirmative action by the Parliament for the benefit of EWS class. It cannot be said to be unreasonable classification. Treating EWS as separate class would be a reasonable classification. Just as equals cannot be treated unequally, unequals cannot be treated equally. Treating unequals equally violates equality under the Constitution. The amendment creates a separate class of EWS. The exclusion of SEBCs, that is the socially and economically backward classes, cannot be said as discriminatory or violative of Constitution. Justice Trivedi and Justice Pardiwala have also made observations in the judgment regarding the need to have a time span for reservations. In their dissenting judgment, however, Chief Justice of India, Lalit and Justice S Ravindra Bhat have underscored that reservation on economic criteria is per se not violative. However, by excluding the poor among SC, ST, OBC categories from economically backward classes on the ground that they have enjoyed benefits, the 103rd Amendment practices constitutionally prohibited forms of discrimination. The dissenting judgment stipulates, and I quote, our Constitution does not permit exclusion and this amendment undermines the fabric of social justice and thereby the basic structure. This amendment is deluding us to believe that those getting social and backward class benefit is somehow better placed. This court has held that Article 16 Clause 1 and 4 are facets of same equality principle. The characterization of excluding the poor of SCBCs, that is the socially and economically backward classes, is incorrect. What is described as benefits cannot be understood as free pass. It is a compensatory mechanism to reparate. The exclusion is based on social origin, which destroys the equality code. Pertinently, they have also opined against breaching the 50% ceiling in matters of reservation. They have ruled that permitting breach of the 50% ceiling would result in compartmentalization and that the rule of right to equality will become right to reservations. For more information on this crucial judgment, you can refer to our detailed report, the link to which has been given in the description box below. Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.